So, what is the forced share? Hi, I'm Claire Langton Yanowitz at the Yanowitz Law Firm, where we help families protect what matters most, including helping blended families. So, um, in Minnesota, we have a required amount that you're supposed to leave your spouse. And you can leave your spouse more than that, of course, but that's the minimum amount you have to leave your spouse. And this is sometimes called the forced share or the elective share. Okay. And this concept is present in a lot of different states' laws, but it's different in different states. What's the minimum amount you have to leave your spouse? And in Minnesota, it's actually quite a complicated calculation, the elective share or the forced share. So I'm going to kind of make an overgeneralization about it, but it's something that you can kind of get the gist of what this means in Minnesota. So in Minnesota, you're required to leave your spouse at least a life estate in the homestead. That means that they're able to live there for the remainder of their life. And then at their death, you can control how it passes at their death. So if you wanted to go to your children or whatever, you could do that. But they have, at a minimum, the ability to live in the homestead for the remainder of their life. Okay. Now, they're also able to receive an amount of the combined estate if they are the lesser wealthy spouse. Okay, so let's say combined you have $2 million. Okay, and the Betsy has 500,000 and George has 1.5 million. Okay. And so in this instance, since Betsy has less than George, if they've been married 15 years or longer, she'd be entitled to half of their joint property. So if George died and didn't leave Betsy anything, in Minnesota's law, generally speaking, she'd be able to get 500,000 from George. So she'd have roughly half of the estate. Okay. But if the tables were turned and Betsy died first and didn't leave anything to George, he couldn't make a claim on her 500,000 because he already owns over half the estate. Okay. So that is something to know. Now, this concept of being able to like make a claim on the augmented estate is something that you don't get 50% after being married for 3 years or 4 years. It's something that accrues over time. It starts at a few percent when couples are newlywed, and it keeps increasing until you hit 15 years of marriage, and then it maxes out at 50% of the combined estate, the augmented estate, which that's a defined term, and it's kind of makes your head spin. What is an augmented estate? But just to make it easier on ourselves today, we're just going to say it's the combined property of the two. So after 15 years of marriage, you don't get more of your combined property of your spouse. That's the maximum amount, is 50%. And so this is something to know, because sometimes people will be in blended marriages and they may say, well, I want to leave my spouse a healthy amount, but I still want to take care of my kids, and I don't want to leave my spouse 50% of my assets. Maybe the person's really wealthy and they think, my spouse is 85 and $2 million should take care of them for the rest of their life. But, I have 6 million in total and I don't want to leave them 3 million. So that's kind of when I see problems arise. So how can you deal with these problems? First of all, it can be helpful if you sign a premarital agreement, a prenuptial agreement. But most of the time when I'm meeting with clients, it's too late. They're already married, either had a prenup or they didn't. Also, Minnesota is not a very favorable state in enforcing prenups. They have to be substantively fair when signed and enforced. And so that concept creates some kind of nebulous on whether, will this be fair when it's enforced? And so will that prenup be enforceable? I don't know. Okay. So prenups are not an ideal deal thing in Minnesota. They sure can help, but it's not with certainty that they're going to be enforced at the time of death. The second thing that you can do is you can have your spouse sign a consent to your estate plan. Okay. So, what does that entail? A consent, we recommend the spouse meets with a different attorney, not part of our firm, from a different firm. And with that other attorney, they're going to go over the estate plan that we've drafted that leaves them less than what they're entitled to receive. And that attorney is supposed to go over them. Look, you've gotten this much, but you're entitled to this much, okay? And you were walking into this eyes wide open. You know what you're entitled to, but you're going to sign off and say you're okay with getting this much. A proper consent should also have a full and total disclosure of the party's assets, so that they're not only consenting to the will or trust, they know how much assets their spouse has, how much they could get at in addition if they didn't sign the consent. So this kind of full disclosure situation. So having them sign a consent is helpful. I think it is also helpful, if you don't want your spouse to overturn your estate plan and assert the elective share, is that you make sure you provide them adequate assets so that they are comfortable for the rest of their lives. Nobody, people are much more likely to contest an estate plan if the moment you die, they don't have a house to live in because you willed your house to, somebody else, right? Or they are left penniless and they don't have any assets to live off of. That makes them much more likely to contest the estate plan than if you leave them a reasonable amount to, live out the remainder of their days. Maybe they're not wealthy. Maybe they're getting less than the augmented share, the elective share, but still they're comfortable. So thank you for your attention. And if you have any questions, feel free to reach out to us. We'd love to help you. Thank you.